Welcome back to another episode of In Their Own Word. The case of Florida versus Sarah Boone was supposed to start today. However, due to the hurricane that is coming in, the judge has pushed the court case to Monday the 14th, where they will start with jury selection. Although we're patiently waiting for the trial to start, the state did file a motion in limine for the judge to consider regarding battered spouse syndrome, and I think it gives us a little bit of insight, so here it is. This is the state of Florida versus Sarah Boone. This is the state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. Comes now the state of Florida by and through the undersigned assistant state attorney and alleges as follows. The defendant has filed a notice, an amended notice, of her intent to rely on battered spouse syndrome evidence in this case. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable. To show in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. The defendant has presented several accounts of what happened on February 23, 2020. She made a 911 call at approximately 1:00 p.m. on February 24, 2020. She spoke to a patrol deputy on body-worn camera shortly thereafter, provided a statement to detectives a few hours later on February 24, 2020, and provided a second statement to detectives on February 25, 2020. That, I think, is Sarah Boone's biggest problem, is that she will not stop talking. The defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23, 2020, multiple times. Exhibit A at the hearing on this motion will be Dr. Harper's deposition, which was taken October 1st, 2024. So they just got this deposition. The state retained Tanya Warner as its battered spouse syndrome expert. Dr. Warner evaluated the defendant on October 2nd, 2024, and Dr. Warner was deposed on October 4th, 2024. Exhibit B at the hearing on this motion will be Dr. Warner's deposition. The state is not asking the court to make any credibility determinations about the defendant's statements to the doctors. That would be for the jury to do, in the full context of cross-examination with the defendant's statements to law enforcement. So they're saying that the jury is going to decide if Sarah Boone is credible by watching her body cam and listening to her statements made in front of the police, and then pairing that up with the deposition of the doctor who is working with her. What the state is asserting is that, as matter of law, what the defendant told the doctors does not entitle her to a self-defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation, evidence of the decedent's violence, so that's Jorge's violence, or battered spouse syndrome evidence to help the jury understand why what she did was objectively reasonable. And here is where Sarah Boone keeps on. The defendant told the doctors that because of the past violence between her and the decedent, she had a generalized fear every day that the decedent would cause her serious bodily harm or kill her. However, on this particular day, the decedent did not take an overt action, even in the slightest, that made her believe that he would cause her serious bodily harm or death. According to the defendant, because she won't stop talking, when she and the decedent woke up, the decedent wanted to drink alcohol. She did not. So in order to distract the decedent, she suggested that they instead clean the defendant's townhome, which they did, and they should have shampooed the carpet. At the conclusion of the cleaning, the decedent still wished to consume alcohol, so the two of them began consuming alcohol. The defendant did not want to consume alcohol, but she did so to placate the decedent. Everything that we've heard is that Sarah Boone does want to, in fact, consume alcohol. A lot of it. I know during her interrogation, they only brought up that they found one bottle of alcohol that was mostly gone, indicating I think that it was wine. But I don't know how two professional drinkers drank about a bottle of wine and were so drunk that this incident happened. The alcohol that they consumed was a Chardonnay bottle by Woodbridge. So that's where I heard that information. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company, perhaps using the dartboard on her porch and doing arts, crafts, and puzzles. Although it apparently would upset the decedent, the defendant suggested he call his daughter, who did not like talking to him when he was drinking, or that he call his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. So it sounds like from statement 14 that Sarah Boone, after they began drinking, that she started antagonizing the defendant. Also, I believe one of Jorge's brothers spoke to the detectives and had indicated that another one of his brothers had gotten a fight with Jorge because Sarah Boone said that Jorge was being abusive. Having done these playful activities for numerous hours, there came a point where the defendant and decedent were sitting on her couch in the downstairs living room, and the decedent tagged her and said, "You're it!" From past games of hide and seek, the defendant understood this to mean that he wanted to play hide and seek. She begrudgingly engaged in this game, as with everything else, to placate the decedent. She ran up to the shower. After becoming cold and perhaps some misunderstanding about the rules of hide and seek, she left the shower upstairs and returned down to find the decedent placing himself in a suitcase to hide. At the time of his death, the decedent was only 103 pounds and had a blood alcohol level of 0.138, which is about twice the legal limit of driving. The defendant saw him doing this and decided to zip the suitcase shut while the decedent was inside. They were both laughing, and there was still no animus between them on this day. The defendant states that she did not zip it completely shut. The decedent was able to poke a couple of fingers through the gap left by the zipper. And then, the decedent said that he could not breathe. The decedent obviously got mad about not being able to breathe. The decedent's getting mad made the defendant get mad. This reminded her of past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. She lost control and the suitcase flipped. She hit the decedent's fingertips with the wooden baseball bat that was in the room. Right away, the police asked a lot of questions about the wooden baseball bat, including to Sarah Boone's former husband. So the state goes on to say that now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-forcible felony of false imprisonment, the defendant believed that the decedent would kill her. Despite believing the decedent would kill her, the defendant flipped the suitcase over so it was right side up, and she believed the decedent would be able to let himself out. Despite believing the decedent would kill her, the defendant flipped the suitcase over so it was right side up, and she believed the decedent would be able to let himself out. The defendant's specific intent was for the decedent to feel like what it was like for her to choke and not be able to breathe. She intended for him to feel this for 2 minutes and believed he would let himself out. And when that happened, if she died, she died. She did not intend to kill him, and she did not believe that leaving the decedent in the predicament she placed him in would kill him. His death was an accident. Legal analysis. Battered spouse syndrome evidence is inadmissible if the defense is an accident rather than self-defense. What that means is that she has to admit that she did the act before she can claim self-defense. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then when the decedent informed her that he could not breathe, she intentionally decided, out of anger, to make him feel like he's trapped in there for a couple of minutes, while she beat and shook the suitcase and hit his hand with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up, saw that the decedent could get 2 fingertips through the opening, and she went upstairs to bed believing he would be able to get out in a couple of minutes. She had no intention to kill him, no intention to leave him trapped inside the suitcase. She did not even comprehend that he could die from this. I believe this statement, except for the fact that I feel like listening to Sarah Boone's story and watching the interrogation, something happened between her taking the video of Jorge in the suitcase and her going upstairs and going to bed. Something happened that her timeline became really fuzzy. I don't know if that was substance induced or if she's not admitting to what happened between the videos being played at like 11:30, 11:45 at night and her going to bed by 12:30. Moving on. The defendant is thus still saying that the decedent's death was an accident, and she is not entitled to an instruction of self-defense or to supplant a self-defense case with reputation evidence, specific instances of past violence, or battered spouse syndrome evidence. The defendant's statement is that she perpetually lived in a state of fear of the decedent is not sufficient to allow for a self-defense instruction, and all of the ancillary evidence of reputation testimony, specific acts of past violence, or battered spouse syndrome testimony. However, before the defendant may introduce evidence of the victim's character, he/she must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Comparing the facts of the cases cited above, it is clear that there was not even the slightest overt act by the decedent in this case. Prior to the defendant committing aggravated assault, aggravated battery, and false imprisonment, there was no imminent threat from the decedent. For example, you can't just attack somebody as they walk into their front door and slash their throat with a knife because 2 days prior they sent you a threatening text message. So the cases they cited said that there has to be a cause and effect that are within a reasonable amount of time. As in, this instance happened, and because of this instance, I felt like my life was in danger and then made this action. If the evidence is improperly admitted, it would be a departure from the essential requirements of the law, which would result in irreparable harm that cannot be corrected by a post-judgment appeal. The state acknowledges that the defendant is entitled to change her story yet again. So if the court does not exclude this evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is a justifiable use of deadly force. So until the defendant testifies and opens the door. If Sarah Boone testifies, she is opening herself up to cross-examination, and therefore all of these statements that she said will be used against her as impeachment. The rest of this document is just the certification that this was filed for the case. So I hope that helps with a little bit of insight into what Sarah Boone has been up to the past couple of days. Again, the biggest problem seems to be that she will not stop talking, and the more she talks, the more she impeaches herself. So if you like this content and you've made it this far, please like, comment, and subscribe to help this channel grow. Thank you.